I'm going to sentence you to 12 days in jail, and here's the reason why. First off, I think 12 days is more than reasonable. This is a penalty that could be up to 93 days in jail, and this is 12 days of jail. There's a couple of reasons why I'm going to. I wouldn't. Listen, that's the second time you've done it. You do it one more time, and I'm going to give you contempt of court and 90 days in jail. I'm just telling you right now. I've always given you your opportunity to say, make a record, and all that kind of stuff, and you're not going to interrupt me. If Mr. Greco had stood up at trial and said, "This moron did," I would have said, boom, right. I would have held him in contempt of court for doing so. You're a citizen of the United States. You can't be a foreign person because you have a citizen. So right now, what you're saying is you could be deported? You can be deported because you're not a citizen of the United States. You already know. You know that getting on your moped and scooting around on the streets is a prohibited conduct. You've already been told that. You've already even pled guilty to it, or were found guilty of it. So you know. Martin. Mr. Martin, you have filed several motions. All right, give me a second to look at this one because it just came up and you just filed it, but I'm sure you're going to make it.
Yeah, I have not seen any of these either. They're filed pro per, so I'm not really sure what he's got up today.
All right, so I had the opportunity to review the motion that you filed today. So let's go through the several motions one at a time. Yes, sir.
I can't hear you. Can you stop talking, please? He was speaking while you started.
Sure.
Sorry. Can you
this is case 231510OT. I had reviewed the other motions that had already been filed. The new motion that Mr. Martin had filed this morning, I was just reviewing that so that he could go ahead and argue these. And we'll start with each one at a time. So the first one is the motion by Mr. Martin. It says the motion is a motion and demand to be compensated for all my time spent at trial. It states that it says I was made to attend the trial on 10/29/24 against my consent, as I only attended by threat and duress, as I could have been arrested, may be charged if I did. Paragraph 2 states I have a right to be compensated for my time spent for attending the trial pursuant to my right against slavery of the Michigan federal constitutions. So, Mr. Martin, as to this motion, go ahead.
Enough for that. So the legal authorities are they're listed there. The MCRs, MCLs that support my position are already listed on there. I have nothing further to add on that stuff. For also, as an extension of that also for the time that here today and every other court proceeding that I'm made to attend with, against my consent. So just want to include them that time also. Every other court hearing too.
Boom, right out of the gate, 12 days in jail. And the judge makes it crystal clear this could have been 93 days, that framing matters. In sentencing, judges often signal restraint to show they're being reasonable. But here's the real question, was this leniency or a warning shot? Drop your thoughts below.
All right, so your motion is denied for the following reasons. The citations that you cite, sure, there is no form of slavery. The 13th, 14th, and 15th Amendments were clearly put into place to abolish slavery, and the 14th Amendment made sure that those amendments, 13 and 15, applied to the states through incorporation doctrine. And but summoning someone to court is not an act of slavery. It's an act of due process. They can't give you due process on your case if you don't show up for your case. It's a little hard to give you a fair trial if you yourself don't even want to show up and don't show up. So you had the constitutional right to have a trial. So you have to be at your trial, because if you're not at your trial, well then the Constitution can't be applied. All your constitutional rights can't be preserved, which they were. And so, for those reasons, and the only other compensation that could come from the Constitution would be under the Fifth Amendment's takings clause. This isn't any real property or any other thing that anyone has stolen from you, and the government hasn't taken it from you. So there is no just compensation, because that would be the only spot in the Constitution that I could think of where that would jump in, and this isn't that case. So that motion is denied for the reasons I just stated. Motion.
You have a response to that?
Denied. No, when I make a ruling on a motion, when I ask you if you want to make a record, that's your chance to put your whatever you're going to say. And you say that, nope, everything is just stated right there in the motion. And I said, okay. And then I make my ruling. Once I make my ruling, that's my ruling. If you want to object to it, if you want to appeal it, you're more than welcome to appeal it and take it up with the court with the next level up there on appeal. But we're done on once I make a ruling on it.
Because that's denied.
Once I make a ruling on it, it's done. So
and preserve the record at the lower court.
Right, but the record is, I gave you an opportunity to make the record, and you didn't have anything to add other than what your motion already states.
So when you say something, then
listen. You're the last. You have competent counsel. There's nothing to say because I've already made my ruling. Okay, so I've already made my ruling. You can make.
I can't say until you say. See, when there's some things like what you just said. See, I didn't know you was going to say. For example, like you just said.
Well, that's not how it works. So
denying my due process right.
I'm not denying your due process right.
Also violating my right to First Amendment.
It's not, because I asked you if you wanted to make a record and you didn't. You said nope. That's the motion says it all, and those things clearly prove me right. That's what you said. So now let's go with the next one. There's a motion demand to dismiss or reverse the order of fingerprinting. It says that your fingerprints are your private property. And Slavens, I'm not sure if you're calling me Slavens, Slavens, as my proper name. My name is Slavin. My last name is Slavin. There is a Judge Slavens. And so just for clarification, the circuit court judge is Slavens. I am Slavin. If you're saying in the possessive, you would need to use an apostrophe. So the use of an apostrophe is not apparent. So I didn't know if you were just misnaming me or if you were meaning the possessive. I didn't know.
But you come up with the S on there because I put an S after your N.
Yes.
Okay, so your name is spelled right. It was just S. Okay, you know some people.
Wait, I didn't know if you were.
They say it with a
sure. I didn't
S
know if it was possessive. I didn't know if you were doing it in the possessive. That's all I was asking. So, Judge Slavin's order that I allow Taylor Police Pigs.
Okay, here we go. The court is slavery argument. This is a classic sovereign citizen-style claim tying compulsory court appearance to the 13th Amendment. But legally, the 13th Amendment abolished involuntary servitude. It does not exempt you from due process. Being summoned to court isn't slavery, it's the justice system functioning. The judge is about to dismantle this piece by piece.
To steal my fingerprints. First off, I'm going to strike the word pigs from your motion because I'm not going to allow any sort of defamatory or derogatory statements to be made. I wouldn't make it. I wouldn't let listen, that's the second time you've done it. You do it one more time and I'm going to give you contempt of court and 90 days in jail. I'm just telling you right now. I've always given you your opportunity to say, make a record and all that kind of stuff. And you're not going to interrupt me. If Mr. Greco had stood up at trial and said, this moron did, I would have said, boom, right. I would have held him in contempt of court for doing so. I'm not going to let you make any derogatory statements about the other side either. I don't run a Jerry Springer show. Okay. Everyone's going to talk with respect to one another. Anyway, so allow the police to steal from my fingerprints without my consent violates my due process rights, my right to sovereignty, to be left alone. Declaration of Independence, 1776. I'm not really sure how the Declaration of Independence gives you any rights. All that was a declaration to King George, telling King George, hey, we're tired of all your crap, and we're going to go our own way, but whatever. The Contracts Clause of the Constitution, by forcing me to act against my consent. Paragraph 2, also, this case isn't about a real crime, but about my exercising my right to travel. Therefore, in reality, there wasn't any probable cause, no injured plaintiff, no standing, no case, no crime. I don't know if it was no woman, no crime. Oh, no, that's the Bob Marley song. We already ruled on all those motions with regard to standing, in regard to all of that. So those are, if you're just basically reincorporating those motions that I've already ruled on, those are still denied. And the order violates my right against slavery, the 13th Amendment of the United States Constitution, which again, I just talked about a second ago, and that was denied. So you can't just say it in two different motions and slip it through or something like that. So that's denied. Now with regard to these, this new part, the part about your fingerprints, they've already denied the other things. Those were already separate motions. You just basically remaking all those in paragraphs 2 and 3. Go ahead and make your record with regard to the fingerprints and why you think that the fingerprints can't be taken.
Because it's my private property, and they can't be taken without my consent. I never consented to it. It was only by threat and arrest, because if I don't, I'll be charged with obstruction of justice, etc. So that's why. And in addition, I'd like to respond also to the statement to clarify. It wasn't a derogatory term. When I say pig, it means persons in government who are violating the oath of office. That's my definition of pig. That's what I use it. Since they've been violating my rights, constitutional rights, that term falls in place in my definition, and it's a true statement. It's not derogatory.
Now we're escalating fingerprints as private property. This is another common legal myth. The U.S. Supreme Court has repeatedly ruled that fingerprints, voice samples, and even handwriting are identifying physical characteristics, not protected testimonial evidence under the Fifth Amendment. In other words, you can't refuse fingerprinting by calling it theft. Watch how the judge explains this.
But just to point that out, didn't mean to cut you off. Like I said, you was done talking, saying something at the time, so I talked. So it was no intent to cut you off. It was just, you stopped talking, I thought I could talk.
All right, so you made your record with regard to this motion. I am going to state that it very clearly states, because I don't find your definition of what pigs really means to be what you were using it as. It literally says, my fingerprints are my private property. In Slavin's order that I allow Taylor Police pigs to steal so you've already designated them as Taylor Police. Taylor Police denotes that, one, they work for a government agency, that being Taylor, and two, their capacity in which they work for the city of Taylor is as a police department or as a police officer. So when you say people in government, I'm not sure what the S was for.
Persons in government.
Persons in government. Then that just becomes redundant. That's like saying the same thing twice. Just say the Taylor Police, the Taylor Police. So I found it to be more of an adjective and a derogatory one at that. For the reasons that no, your fingerprints are not personal property, nor is your handwriting, nor is your voice, nor is the visual imagery of your face and body. All of those things that the United States Supreme Court has ruled on. Stating that it's not your personal property. Same as your garbage. You can throw your garbage out and I can go through it. The police can go through it. Those are things that you do not have any privacy issues relating to. And they are allowed to take that anytime there is a statute that requires the fingerprints be taken in a criminal matter. I was effectuating that order pursuant to that statute. And so your motion is denied for the reasons I just stated.
I object to that.
Didn't object to it.
That's, it is my private property.
But it's not.
I'm God's creation. I'm not. Well, before I get to that, statute cannot violate the Constitution. Constitution violates the Constitution. Statutes that violate the Constitution are invalid. So a statute that says that we can take your fingerprint.
These are all things that you're going to want to put in your appeal, because I've already made my ruling. So, all right. Now, with regard to the next matter, let's see. Let's go with the next one. All right. So, at trial, this is your demand for a new trial based on the following. Paragraph 1, we were denied, I'm not sure who we is, but we were denied a fair trial with the unfair due process violation, guilty finding as so-called Judge Slavin. No, I am called Judge Slavin, so it's not so-called, so that's derogatory. Just saying. So I'm just going to tell you in the future, if you file any more motions with me where you use derogatory statements against people, parties, officers, employees, anybody, I'm going to strike it, because I'm telling you right now, that's not how you do your pleading. You don't put that stuff in there, all right? And so, refusal to allow me to show the jury the evidence, superior law that demonstrates we are not guilty as a living private. So I'm not sure if the tense is wrong or the person is wrong, because you're using we or are as a living private sovereign citizen man. Man is in the singular, but yet we and are both plural tense. I'm just not really sure what you're saying there. The bullcrap state statute, again, derogatory. Paragraph 2, the prosecutor failed to prove in actuality that we as one, I don't know, it sounds almost like the Borg type of a thing going on. We as one of the sovereign people were liable to the so-called statute, derogatory, that is, refused to prove with evidence that we were liable. Instead, he just suggested to the jury that I am liable to it just because of not having a driver's license, and the jury being uneducated in the law, idiots. Again, that's derogatory. You're literally taking somebody in the most purest form of self-governance. Literally, to me anyway, as somebody who loves the Constitution and loves the fact that hundreds of years ago, some individuals came up with a system of free governance, of self-governance, of rights and protections that still holds so valuable today, and how well done they did that. Yes, there's some minor things here and there that need to be fixed, but they're not elected people. These are people who are summoned to court, come, sit down, listen to the facts of a case, and they literally, because you don't get this kind of treatment anywhere else in the world this well, where you are basically going to be judged by a jury of your peers. They don't care if you're guilty or not guilty. They're just going to hear the facts and then make a decision. And they're not elected. They don't have any stake in the matter. They don't have a quota to meet, nothing. So for me, a jury, serving on a jury is literally the most pure form of self-governance that there is. It's just, and for you to call them idiots, not only does that just make a derogatory statement towards all those people who decided to make sure that they were exercising their constitutional right, because they have a constitutional right to serve on a jury even. And the fact that they are there to protect your constitutional right to a fair trial. And for you to call them an idiot, it literally just takes everything in my power not to just like, wow. The second thing is I instructed them in the law. So they weren't idiots. They knew exactly what the law was. They knew exactly what the law and what they were there to do. They were there to hear facts, and they were there to hear that and base that and judge those facts up against the litmus test of the laws that I had instructed them, which was on the driving on a suspended license law. So for you to call them idiots it's disgusting. I'm sorry. So you continue with, because of not having a driver's license and the jury being uneducated in the law, idiots.
All right, now we're getting into actual criminal law doctrine, mens rea. This is serious territory. Mens rea means guilty mind, and yes, most crimes require intent. But here's the twist. Ignorance of the law is almost never a defense. Believing you're right because you read a case online doesn't erase criminal intent if you knowingly committed the act. This is about to turn into a legal chess match.
Just accepted it without actual evidence to prove liability, paragraph 3, because of so many legit defenses I raised at trial. I forgot to raise at trial my defense that I am not guilty, because even if Judge Slavin, prosecutor, jury didn't fairly believe I was not guilty based on everything I said before, I am still not guilty because I didn't have a guilty mind. Based on my reliance of prior superior law that told me I wasn't doing anything wrong by exercising my right to travel with my private property, such as the due process clause of the Michigan federal constitutions, among my other cited legal authorities, I cited in my written and oral. Okay. Paragraph 4, a guilty mind mens rea is required in crimes. It's more set in the United States, and also a House bill signed by Governor Rick Snyder and passed unanimously. Also fairness, fundamental fairness, due process, Michigan constitutions, federal constitution. All right, so you're claiming that, I don't know, you're claiming that you should have not been, I just want to clarify exactly. 1, because the jury was stupid. 2, because you had already, because I didn't grant your motions that you made at trial. And 3, because of mens rea. You didn't really say what you meant about mens rea, but just that you needed to have mens rea in order to be found guilty. But there was, so go ahead and make your record.
Well, first let me clarify about mens rea. As I stated, okay, because I'm relying on U.S. Supreme Court case law that says I have the right to travel and driving a motor vehicle is not driving a motor vehicle unless one's using those for profit, as I heard before. But regardless of you agreeing with me or not, and deny my demands to dismiss what you did, regardless of that, by the fact that I'm relying on these laws, in my mind, I'm not doing nothing wrong because I'm using U.S. Supreme Court case law and the federal statute, 18 U.S.C. section.
So let me ask you one question before you go on, because I need to know for clarification purposes. When you say, because you referred to it in the motion, you referred to it verbally just now. When you say, when I acted, I didn't think I was doing anything wrong because of the different things you stated. Okay.
No.
What is it that you did? What action did you take that you relied on these laws? It wasn't in the motion.
They call it driving.
Okay.
Okay, my moped. In fact, I was traveling by right because the traveling by right term means when you're not using the roads for profit, as the case clearly says that Packer versus Banton, the U.S. Supreme Court case, the quote, it clearly says the legislator cannot regulate the use of the roads unless you're doing it for profit.
No, sure, absolutely. Listen, you have a right to travel. I've said it 100 times. But you can't travel by plane either. You have to have a pilot's license. So there's licensing requirements. So we've already gotten to that. So skip to the part where the mens rea kicks in that you say we don't have it.
This supports what I'm saying. But anyway, so yes, it supports this thing. Without a guilty, you need guilty mind in all crimes. Okay, anyway, so back to you, Slayton. So because I'm relying on, like I said, the Packer versus Banton case, which says the legislator cannot regulate the use of the roads if it's such as the driver's license, you need insurance and need registration if you're not using the roads for profit. And plus, I'm relying on that legal authority, 18 U.S.C. section 31, subsection 6 and 10, federal statute made by Congress, which makes it clear that a motor vehicle is not a motor vehicle unless it's being used for profit. Same thing as U.S. Supreme Court. Article 6 of the U.S. Constitution makes it clear that federal statute I just named off is supreme law of the land. So, because I'm relying on this higher supreme legal authority, in my mind, I'm not doing nothing wrong, and I'm not guilty. In fact, that in addition to these cases I just cited, Morissette versus United States, U.S. Supreme Court supports a guilty mind is needed. Plus, as you just mentioned, the House bills signed by Governor Rick Snyder, and it all supports mens rea. Guilty mind is required for all crimes, and that's how it should be. That's what's fair, and that's what's right for the people. So,
you made your record?
Yeah.
Okay. So first off, you're correct. You do need a mens rea. There's a mens rea, guilty mind, actus reus. Okay, that's your actual acts and stuff like that. Also, as I instructed the jury, you can have direct evidence, you can have circumstantial evidence. But there's also the maximum of the law that says ignorance of the law is not an excuse. Obviously, this is clear in your case because ignorance of the law is just explicitly obvious here. So, the law states that no person who has a license that's been suspended, revoked, or denied shall not operate a motor vehicle on a roadway. Plain and simple. So you even stated that you were operating a motor vehicle on a roadway. Now your definition of what you think the definition is, which is not the definition, because we actually pulled up the federal statute when I denied your motion last time, and I actually read from the federal statute and then stated what the definition of motor vehicle is. And your interpretation of a motor vehicle is not the right interpretation. So the fact is, you knew or had reason to know, because let's talk about mens rea. Mens rea is guilty mind, but there's different forms of mens rea. There's negligent types, there's reckless types, there's knowingly types, there's purposeful types. Yours in the statute that you have would be knowingly, like no one should knowingly, like I know my license is not suspended, or I know I don't have a license. And everybody knows, like it's almost like common knowledge that you can't drive without a license. Everybody knows that. And even if you didn't, ignorance of the law is not an excuse. So the law clearly states that you shall not drive. But yet you went ahead, and so what does knowingly mean? Knowingly means that an actor or the person who's doing things is almost practically certain, like they know that their conduct could possibly lead to a result or they're aware of a high probability that their conduct is prohibited in nature. Now, I'm going to point to the fact that you have a 2022 operating while license suspended, revoked, or denied guilty plea. You were found guilty in 2022. So you know that driving on a suspended license is a crime that's going to be prohibited. Why? Because you've already found guilty of it. You already had a case for it. I don't know if you went to trial. I don't know if you took a plea. I don't know what you did. But you knew that, hey, you got to have a license to drive. Now, that was in Dearborn. And you know what? Dearborn, Taylor, it doesn't matter. You need a license. State of Michigan. That's why the license comes from the state of Michigan. It doesn't come from Taylor. It doesn't come from whatever city you're from. It's a Michigan driver's license. And you already know that getting on your moped and scooting around on the streets is a prohibited conduct. You've already been told that. You've already even pled guilty to it or were found guilty of it. So you know. So the fact that the jury found, because all they have to do is prove, because by circumstantial evidence, I don't think God or any other alien or any other person or any other under duress or anything like that or under threat of violence, get on that moped right now or I'm going to beat you. Like nobody threatened you to get on that moped and drive it around. So all they had to do is prove that you were just driving it around. Circumstantially, we can infer that you chose to get on said moped because you call it your personal property and you chose to drive it. So that's the mens rea. That proves your mens rea. People are thinking about the way they're acting. You're driving down the road on your moped. That's all you had to do to prove mens rea. So mens rea was proved. It was proved. Because for example, if I have, let's take a person and I can say, here's a guy, Turd Ferguson, we'll call him. And he goes into a bar and he starts chirping at some guy and he gets up and punches this guy in the face. If I see and witnesses see him walk over and he's already been chirping at him and he walks over and Turd Ferguson punches the guy in the face, you can infer his intent by his actions. Because most people don't walk around saying, I'm going to take a drink of my drink. I'm going to punch Turd Ferguson in the face. They don't walk around saying, now some people do. You're like, dude, keep that in your head, like your own thoughts, you know. That little baby's ugly. You know, nobody says that. You don't say, shh. All right? So most people don't. But what we do, and this is why they allow circumstantial evidence, because you can infer people's intent by their actions. So your intent, your mens rea, your guilty mind, was already inferred from the fact that you know that it's a prohibited activity. You know that you've already been found guilty of it once before. You literally you chose to get on your moped and go scooting around the streets of Taylor. Your mens rea is shown and proved from that. So for that reason, this motion is denied.
Object to that. So it's okay if I talk without being threatened with contempt and all that? Or?
I've never threatened you with contempt at all. I told you if you interrupt me again, I'll hold you in contempt.
Yeah, so again, you're talking about violating the state statute that's unconstitutional, therefore you can't.
Again, that's all for your appeal.
Right, so
you've already made your record. That's what I've asked you if you wanted to make a record. So the one you filed today, let's look at that one. Enclosed for filing is the demand to dismiss or discharge all these cases based on 28 USC 1604, immunity of a foreign state from jurisdiction. Demand to dismiss these cases based on lack of presence of plaintiff at trial. Okay, so.
And now the diplomatic immunity play, claiming to be a foreign state under federal statute to escape jurisdiction. Here's the legal reality. 28 USC section 1604 applies to actual foreign governments, like France or Poland, not private individuals declaring sovereignty. Courts have rejected this argument thousands of times. The judge is about to read the statute out loud, and that's usually not a good sign for the person making the argument.
First off, this is basically, I guess, two different reasons why you think that the trial and what happened should be dismissed. So first off, let's look at 28 USC 1604. And yes, that does state that, and I'll read it right from it for you. Immunity of a foreign state from jurisdiction, subject to existing international agreements to which the United States is a party at the time of the enactment of this act. A foreign state shall be immune from the jurisdiction of the courts of the United States and of the states except as provided in sections 1605 to 1607 of this chapter. All right. So this is interesting. Either you are an international man of mystery who makes agreements as a separate foreign corporation or state, or, wait a minute, there's a definition for foreign state. Section 1603, if you had read that section first, it clearly states, for the purposes of this chapter, a foreign state, except as used in section 1608, includes a political subdivision of a foreign state or an agency or instrumentality of a foreign state as defined in section B. So let's look at section B. An agency or instrumentality of a foreign state means any entity, one, which is a separate legal person, corporate or otherwise, and two, which is an organ of a foreign state or political subdivision thereof, or a majority of whose shares or ownership interest is owned by a foreign state. And three, here's the important one, which is neither a citizen of the United States, as defined in section 13322, and nor under the laws of any third country. You're a citizen of the United States. You can't be a foreign person because you have a citizen. So right now, what you're saying is you could be deported? You can be deported because you're not a citizen of the United States. Because in order to be a state, so just curious. So and the reason I'm kind of already going with that first is that way you can make a record and you know what I'm saying. You know what I'm going to say. You already, because I haven't made my ruling yet, but you can see why you're not a foreign state. You're not France. You're not Poland. So go ahead, make your record.
Well, first I was going to say no, I'm not a U.S. citizen. That's false. A U.S. citizen is slave. It's not one of the sovereign people. And actually, U.S. citizen doesn't really exist. I mean, when they try to, people ignorantly call themselves U.S. citizens. They don't even know what that term really means. It really means a corporation, so that's why they're really not. But anyways, yes, I am a foreign state. As I pointed out in there, and as that volume mentions, foreign state is a synonymous term with one of the sovereign people, and it's also goes within the synonymous with the term states of the union, which also means one of the sovereign people. And so, if you don't know that, you look more in the Black's Law Dictionary, look more in the term of states, it doesn't just mean a corporation always. It does mean, one of the sovereign
the statute says so. It says it could be a person, could be corporate, could be part of an agency.
Well, I'm not a person. Also, as
so right
now, I'm not a person.
But you're a citizen of the United States. You're a citizen of the United States.
No, I'm not a citizen of the United States. I'm one of the sovereign people, which the U.S. Supreme Court said.
Okay, then so the bridge card. I'm going to call the bridge card place and tell them to stop sending that to you because you're not a citizen.
No need. Well, I can't just.
Hey, it's funny how as a citizen, because you kind of want to take advantage of the rights and the benefits of being a citizen, but you don't want to claim as a citizen when it comes to criminal stuff. I guess is that how it is.
I understand all the law actually.
So are you waiving any? Just asking you a question. Are you going to waive any and all Social Security payments that you should ever receive? Because you're not a citizen, so I mean, I'm just curious.
I received SSI payments and all that, but anyway, I'm saying my comprehension of the law is you're not allowed to be denying human and constitutional rights because you may accept benefits from there's law on that too. Actually, I can point that out.
Okay.
I haven't written elsewhere, but.
Well, I do find that you are
just because you take a benefit of something, or what's called to be a benefit, you're not allowed to be denied your constitutional inalienable rights just because you get what's called a benefit or whatever.
You're saying a bridge card is an inalienable right?
I think the right to live, but you're not starved to death. You're not starved to death. Yes.
No, it's not. It's called get a job. It's called go back to the country.
I do my best. Evidence supports it. I've been applying for a job over and over and over. Haven't had the luck. That's all.
They haven't. None of them have hired you.
Well, I'll tell you what. If you have a job, you let me know. I bet I'll be willing to start today to prove I'm willing to work always. I'm not a loser. I'm not someone who's always looking for handouts.
So basically, based on the actual statute, 28 USC 1603, which defines what foreign state is, I find that you're not a foreign state. So section 1604 does not apply to you. And so for that reason, your motion is denied.
And you said it doesn't apply because of why? Am I clear why?
Because you're not a foreign state. Simple as that.
Did you read the section I put that Corbett for a second on that says that the states of the union
true.
Listen,
you can cite to that, and that's not legal precedent. I'm going to look at statutes. I'm going to look at case law.
Well, I know
do you even know what corpus juris secundum is?
Yeah, I realize it's not. I was going to say binding. It's not the U.S.
Right, it's not binding. That's right. So exactly. So I'm not looking at anything that's not binding.
But I'm going to elaborate.
What I am going to look at is the statute. The statute defines foreign state, and that ain't you under the definition. So, because I find that you are a citizen of the United States.
Let me elaborate on it, but I'm going to say that it is binding authority. It does verify that and say the same thing. I just don't have it right now. But it is.
Well, right now is when we're doing the motion, and the motion is denied. So, all right. So those were the motions, the four motions that were in front of me. I've made my ruling on those motions. You're more than welcome to take those up on appeal. Now,
one more.
There's one more motion that you filed or didn't file?
Yeah. It was the same time as the one for the foreign sovereign argument. This is the ban to dismiss all these cases based on the lack of presence of the plaintiff at trial.
I already ruled on that because you talked about how I ruled on it during the trial because you made the motion during the trial that they.
I remember if I did right.
You're more than welcome to order the transcript. I've already made a ruling on that. You basically stated that it's a corporation, et cetera, that they, and so I made a ruling on that during the trial. So.
Could you first remember? I don't remember what you said on that. And what did you say on that?
I don't need to refresh your recollection. You can order a copy of the transcript if you like. If you're making an appeal, you're going to need a copy of the transcript anyway. So.
Look, we just go over it now. Anyways, I like to go over it now and refresh my memory and say what I got to say. And
I've already denied your motion because it's one that's already been denied. And the same, basically, you're bringing up standing and all that, saying that the city of Taylor is not a proper plaintiff to bring a case. And you did that during trial, so before the trial, actually.
This is a little different than standing. This one I interjected.
No, I'm saying it was part of all the other motions that you made before we began the trial. So the motion is denied. You can, if I'm wrong, then they'll grant your appeal. So they probably will. So, all right. Now, today is the date and time set for sentencing in this matter. And there's a pre-sentence investigation report. Are there any additions, corrections, deletions to be made?
just asking you if there's any additions, deletions, or corrections that need to be made to your pre-sentence.
Yeah.
So we're gonna do it by sections so that we can follow along. Your prior criminal record, I see 1, 2, 3, 4, 5, 6, 7, 8. 8 different things. Is there anything in the 8 different matters? Is there any of those that need to be corrected?
Well, first I want to say they never, they don't refer to me as a living man.
Listen, here's, I'm going to make a ruling right now, once and for all, on this whole living man thing. You literally, I get that you are a living man. You're obviously speaking and talking and breathing. So dead people don't breathe, talk, and do that kind of stuff. So I've already told you that once before. And so giving yourself some sort of new nomenclature, some sort of like, all right, I am the Rasha Bambata of Zimbabwe, but I'll just make stuff up too. All right. Listen, you're Eric Martin. You're sitting here in my courtroom. I know who you are. I'm asking you to tell me, are all of these on the criminal record? Is there anything that's like missing? Is there anything that's added that shouldn't be there? Is there any additions, corrections, or deletions to be made to this section? Simple as that. Answer the question.
Right. Well, actually, that was part of me saying it's not right because
first off, I'm not hearing this whole living man thing. All right. So I just told you that. So go ahead and let me know.
But yes, okay. Well, answer as far as what I say is besides that, it's not factually current. Besides that,
So he's asking about these first ones and the convictions that you're challenging.
This right here is the turning point. The judge brings up a prior conviction for the exact same offense. That's devastating to the mens rea argument, because once you've already been convicted of driving on a suspended license, it becomes nearly impossible to argue you didn't know. In criminal law, prior knowledge can establish awareness, and awareness fuels intent. This is where the defense narrative starts collapsing.
Well, one, they shouldn't be even mentioned because already been punished for them.
It's a sentencing. This is a sentencing, and I need to know.
Under the double jeopardy clause, they shouldn't even be considered or looked at because already been sentenced and punished for them, so they shouldn't even have no relevance even looking at them, really. So.
All right. So, are there any additions, corrections, or deletions? I didn't ask about any actual articulation about it or any opinion about it. I just asked you: are those past crimes that you had? Are there any missing? Are there any that shouldn't be there because they're not true? That wasn't there. You didn't actually. And I don't want to hear, oh, well, I really wasn't guilty. It was, some sort of. You were found guilty of these things. So, by trial or by plea. So.
Well, that's the only position I have on as far as them not being rated as.
Okay. So moving on. The pending court matters. You currently have 3 pending court matters for driving on a suspended license. There's a warrant. You have a warrant, open warrant on that one? Is there an open warrant on that one? Did you fail to appear or something?
No, this thing, this situation. I was just.
I don't need, because first off, I'm going to let you know you have a constitutional right to remain silent. I don't want you to speak or anything on an open or pending case. I'm just saying, are you aware that you have a warrant out of Ypsilanti?
Yeah, I heard of it. But it's not for me. But the thing is, yes,
okay, then that's all. Because anything, because I'm.
Let me elaborate on what's going on with the situation.
Listen, I don't need you to elaborate because everything in here is being recorded, and they can use any of the facts that you state on the record here.
Criminate myself anyways. I just want to say the situation, how it's really illegal because I was there.
I don't have jurisdiction over your Ypsilanti, and I don't know what happened in Ypsilanti, and I don't want to know. I'm just asking, is there any other court cases? You have a Ypsilanti driving on a suspended license, and then there's 2 domestic violence cases out of Taylor here. So are there any other pending court cases that you have that aren't listed here? Is that correct? Is there any additions?
That seems correctly, yeah.
Okay. Age 51? Is that correct?
That's what I'm saying, but I want to say it's,
there was a date when you were living, you had a landlord tenant thing going with your mom, inside your mom, and then all of a sudden you were outside your mom.
That's what I've been told, but I was too young to know how old it was when I was born, actually.
Okay,
so it's really hearsay evidence as to my date of birth because I was sworn by what someone else said.
All right, so sure. So, but for the best, so basically you don't know whether or not you're 51 or not 51, but it could be possible, but it might not be possible.
Well, like I
Sure.
said, I was too young to remember.
Sure. How about sex? Do you know your sex?
When I was born.
Sex, male?
So
Correct?
it's really hearsay evidence as to my date of birth.
Okay, I'm moving on from the date of birth then.
Right. Okay.
Sex, male, is that correct?
Yep.
Single?
Yep.
Children, none?
Right.
All righty. So now, employment basically states that you're not currently employed. You had been employed in the past, but you're not currently employed. Is that correct?
Well, like I just.
It's just a yes or no question. Are you employed right now, or yes or no? You just stated a couple minutes ago that you don't have a job.
Well, it's the thing. It's not so simple like yes or no. The
But it is. It is.
Well,
I'm either awake right now or I'm sleeping right now. Wait a minute, I'm talking, so I guess I'm awake. So do you have a job right now, or do you not have a job right now?
Just doing Uber on a bicycle sometimes.
Okay,
So I'm not sure that's
once in a while doing that.
like,
Okay,
yeah, that's
sure.
right.
Education level, it says that, I don't know, you went through the 6th grade, that's what it says, or you got your GED in 2013, is that right?
Yeah, so
Okay.
I couldn't remember. I told him what it was.
All right.
That was my best guess.
Are you currently residing with your sister and brother? Well, you're not, because you were told not to be in the same residence, so you're living somewhere else?
No answer to that because that's probably self-incrimination, even if.
Well, because there's a bond condition not to have any contact with the.
Which is illegal, right? Because it's.
Which is not. I already ruled on that motion.
Delegation.
That motion was denied. So,
Yeah,
all right. So, with regard to your summary,
yes. Okay. Now, yeah, I object to the part. Calling me a defendant. Because, like I said before, one of the summer peeps, I just
listen. Here's the thing. I'm just going to say right now, they're just all it is just a word. It's just a word referring to you, because you have to use a pronoun or a proper noun in order to refer to things. Like, I don't know, Turd Ferguson is a tall man with a mustache. I don't know. That's just adjectives. Or I can say that guy is tall and has a mustache. That guy is, so defendant, we're just using it right here to refer to you. They're talking about you. I want to know. And so what about the facts? What about the substance of this? Not into the whole defendant, don't call me this, don't call me late for dinner. So that's what all that is. Just get to the substance of it, like the actual nuts and bolts here. Okay. So is there any additions, corrections, or deletions to make to the substance of it?
Yeah, so, okay, and then, like I said, besides that, where the statement is mentioned, he says, I say I'm a master witch and magician in training. Okay, I did say that.
Okay, so you are a master, so these are
I'm
all
not a
correct
master yet in the training, in the process of becoming.
You're training to be a master magician or witch, or is that the same thing, or?
Both, it's slightly. The witch is one who practices witchcraft, the religion of witchcraft, and magician is strict magical practitioner. But I'm both. But anyway, so his statement that it's leading to questions about his mental stability, just because I state that, it doesn't mean someone's mentally unstable. So that was totally foolish for him to say that and irrational. So.
Well, they're not making any conclusions. They're just stating, hey, judge, these are some of the things you might want to just look into. This is just the only reason they're doing this report is just to kind of give me a general heads up, just a general feel of what they saw. They're not asking for anything in particular until they get to the actual recommendation part. But the rest of it is just like a report, just to kind of like meet with you, kind of like, that kind of thing. So they're not actually inferring that you are mentally unstable.
Well, he did state, the statement's right here. I'm referring to the statement why I say that, because it says leading to questions about his mental stability. Like, that leads to the question. That doesn't lead to a rational question whether someone's mentally stable, because they're a witch and a magician. That's just total nonsense for them to even say that. It leads to one to even question someone's mental stability.
Duly noted. What's the next issue?
Yeah, so and then I denied the next thing, that I had a difficult time staying on topic. I deny that statement you put in.
Okay.
So, I mean, talking about the law, I was doing some talking about the law, but then I couldn't help myself or something. Like he's trying to suggest that's just a bunch of false. That's false. But anyways, what's next?
Okay, what about the being uncooperative with the interview process? Were you being cooperative?
Yeah, I don't know. That's not true, right? I bet you don't have a recording that supports that. Point that out. So these statements are not supported by sufficient evidence.
Okay.
I think maybe I made it said that because I was talking about somebody tried to cut me off, maybe, or I just wanted to elaborate more, maybe. But I'll eventually answer all his questions eventually. You know.
Oh, I see.
So all I had to do is, I don't know, be a little more patient, maybe, and my best guess. And,
Sure.
but I know for sure I didn't refuse to answer anything. Anything you want to ask me?
What about the felony convictions that you stated that you had never been convicted of any felonies when they asked you?
Well, like I said, I say that based on my knowledge of the law that humans are not really convicted to legal fiction corporate entities that are. That's based on my knowledge of law.
Do you realize that most things are fictions, right? Like, what color is your shirt?
No.
What color is your shirt?
So greenish blue and black.
Greenish blue. I would have went with greenish blue as well. I would maybe a teal, greenish. It's greenish blue and black, or it's schnarg and flarg. Because greenish blue, even the word blue. You know, words are all fictions. It's just something that we decide to just collectively use so that we can communicate. But it's a fiction. Blue doesn't exist. Like the essence of blue is just a word. It's just a description. It doesn't exist. There is no blue. Blue is just nothing more than light waves.
Energy.
See, that's what happens. Is light hits your shirt and it absorbs every color except blue. Blue bounces off of that material, or at least the frequency, the wavelength frequency of blue light bounces off of it. So now we perceive that color. We perceive that look, but it's not real. It's just wavelengths of light. We call it blue. We call it defendant. We call it a felony. We call it a conviction. We call things because that's the only way to communicate. You got to come up with like an agreed upon word, hence the dictionary, because you always like to refer to the dictionary. That's why we have dictionaries, so that everybody can be like on the same page when we use fictions, because it's all make believe. So when you make those arguments, it doesn't really help. You know what I'm saying? So why would you tell them? So basically, you're not disagreeing that you had felony convictions. You're just saying that in the way you believe the law should be read, is that as a human, I was never actually convicted of anything. Right, I can't be convicted. All right.
I was fraudulently
just make it
defended.
Fraudulently. Okay. So yeah, but all right. But you can understand how somebody who would think that you're just not answering the question. I mean, you see what I'm saying?
Maybe he doesn't know the law, maybe, but I explained that to him too, though. That's the thing. As he mentions in there, I was talking about the law, so I was explaining things to him to understand where I was coming from. I'm not just saying things that don't have no basis and all this. Whatever.
All right. So how about anything else? So that and I see you went and talked about the traveling part and things. Well, anything else in here needs to be corrected, changed, looked at?
Okay, yeah, no, so, well, you know, first as to the term, as I already said, driving a license, it means only for commercial, so that's why I said I wasn't technically driving. These ones I just put it in anyways, like I was. Anyway, so, in response to this question, he said that I don't need a license to drive. I never said I don't need a license to drive. I understand the real legal definition of driving means, and that means, like I said, commercially. As I said before, the federal statute's definition and the Supreme Court's definition, Hacker versus Banton, says that, not just me. So that's why I deny his statement on that. I never said I was driving. I don't need a license to drive. I don't need a license to travel by right, which is done on commercial, so which is doing it on commercial. So anyway, so I deny that. But anyways, in addition, the statement that I blame others for my employment, financial, and family issues, that's not factually occurrent. I don't remember blaming others for it. So that's not a true statement. So it seems like he's trying to make me look bad or something, like making these false allegations.
Okay.
But
any other corrections, additions, or deletions with regard to the report?
No, and I don't know. Now, I was going to say, as far as now the fines, it's more of a legal thing, I guess, but I don't agree. Of course, all these fines that me as one of the sovereign, I am subject liable to it, especially when there's no victim to Peter. And I got other legal arguments on that. That's more of a legal thing, but fact-wise, that'll be it. But I have some legal arguments as to these fine recommendations based on supreme law, binding authority, you want to say, supreme over this state statutes that
Okay.
And that is, are you ready for that?
Yeah.
Okay, so.
Do you say supreme law? You're talking about the Constitution, right? Because this is
Constitution, yeah,
supreme law of the land, Marbury versus Madison. Yeah.
Yeah, and federal statutes that override state statutes, you know, the supreme. All right, so first, as to any fines, 12 USC section 411, federal statute made by Congress, makes it clear the obligation of all Federal Reserve notes belongs to the United States.
Sure.
Therefore,
now, let me go ahead and clarify that for you.
Okay.
That basically just means that when the federal government issues $1, that means it's worth $1 and you can use it for $1, and they're guaranteeing that.
Okay. Well, I deny. He was talking.
That's what it says.
Did you say repeat again?
Sure. No, you just said that all Federal Reserve notes are guaranteed by the government. That just means that if I go to pay for something and somebody says, "Well, I can't take this; it's not worth $1," and I'm like, "Yeah, it is," and the government will back it up. They're guaranteeing that it is worth $1. That's what that means. That means that you can use it, because if you didn't have that statement, if you didn't have that statute, you wouldn't be able to use money as currency. It would be useless. It would be like no one would trust it. So if you don't have the government actually backing it up and saying like that's why I said this is a Federal Reserve note. That statute says we guarantee that IOU, that we will pay somebody $1. Somebody will get $1 worth of things. They're like guaranteeing it, because if they didn't, it would just be paper and it wouldn't mean anything. Who cares? That's why we would need gold then, because that gold actually has value and you can track. That's all that statute means. But go ahead.
Well, yeah, no, that's still of the position, because word for word, as written down, I'm going to say it still supports my position. I'm not subject to pay no fine, because as it says, the obligation of all Federal Reserve notes is by
right. The obligation means that the bearer. It says
that's
the bearer.
discharge of the U.S. government. So I'm saying I'm discharging it.
Okay.
Any fine you try to impose, I discharge it and put the bill to the U.S. government.
Okay.
And also, House Joint Resolution -192 also supports my position on that because there's no real money in circulation. Federal Reserve notes are not real money. The U.S. Supreme Court has said that. Because all the gold and silver have been taken away.
Which is why they have to have that statute that guarantees everything, so it makes it real money. So, okay.
But I just want to point that out. So if you any fine,
Sure.
House Joint Resolution -192, the statute is named off.
Sure.
It's to be discharged to the federal government,
Okay.
and also would fall under Declaration of Independence of 1776 that governments derive their just powers from the consent of the government. So I never consented to pay money, nor do I. And
You realize that that's not a statute, right?
it's part of the Constitution. It's better than a statute. The Declaration of Independence.
The Declaration of Independence is not part of the Constitution.
It's based on the U.S. Constitution, based on that, and I read.
It's not part of the Constitution. It was a letter written to King George, basically saying, "Yeah, we're too bad, so sad. We're out of here, and you guys can, you're not going to tell us what to do anymore." That's what that was.
Isn't it the U.S.
It's not a
Constitution
statute.
based on the
It's not a
Declaration?
statute, so you can't cite to it. But go ahead. What's
Isn't it
next?
true that the U.S.
What's next?
Constitution is based on the Declaration of Independence of 1776?
Move on to the next one.
And also, now any action, complaint, transaction initiated by the state, federal agents, or commercial in nature in light of the fact that they impose a quasi-monetary fine in violation of Article 1, Section 10, Article 11, Section 1 of the U.S. bankruptcy. No person shall be imprisoned for debt. I also want to point that out as to any consideration or thought that I should be in jail or prison. Article 1, I'm going to let you talk. I'm going to finish my train of thought here first. I'm going to let you say what I'm going to say. No person shall be imprisoned for debt. That's Article 1, Section 21 of the Michigan Constitution. So, certainly shouldn't be imprisoned for debt. And first I want to say, this so-called crime is really commercial in nature. All crimes are commercial in nature. And what supports that is Code of Federal Regulation 72.11. And if you have any dispute that the so-called crime is not civil in nature, not all about money, then I ask you to dispute it in reference to evidence and law that says otherwise. So since it's civil in nature, you can't be imprisoned for it, and the other reasons I can't be fined for it, none of this should be taking place. Can't be jailed, can't be fined for it under higher supreme law.
Is that it? Counsel, do you have anything to add?
If I just have one moment.
Sure.
And, oh yeah, I want to give him the chance to say anything.
Do you want me to make any actual statutory arguments under Michigan law?
Let me see what you got.
It's a statute.
Do you want me to read it?
No,
Never know.
it's no. It's
As long as he doesn't deny my.
Never mind.
position.
You want my help or not?
Is it going to help my position? Sure, go ahead. Let me see what you say.
Yeah.
I'll just object to it if I don't agree. Go ahead, say what you say.
Yeah, I have no further argument then. Again, if he'd like a moment to speak with me, I'm happy to explain to him basically the rebuttable presumption under 769.5 for non-serious misdemeanors to a non-jail, non-probationary sentence, which I understand under subsection 3 is the starting point. Subsection 4 allows the court obviously to rebut that presumption and order probation or jail if there's factors that are met. I was trying to advise my client simply what that argument would or would not be, where he can now make the arguments to this court under 769.5 as to why he feels the sentence that he's asking for will be appropriate. I think I know where he's going with this. I'm just trying to move him to the right statute to make that argument, and then allow this court to hear that argument, and then you can make your decision, obviously, with full discretion of what you think is appropriate. So, real quickly, what I'm trying to say, 769.5, subparagraph 3, states that a non-serious misdemeanor is non-jail, non-probation, but the court can rebut that presumption under this other section if they find the basis to do so. Do you understand that?
I do not understand. I do not stand under the state statutes. I'm not.
Your Honor, my client's indicated he doesn't believe the state statute's applicable to him, so I'll withdraw the argument and would just, again, rely on whatever Mr. Martin
Unless,
feels.
there's an unless.
This is an attack team. Either you want me to make the argument or not under the statute, that's what you're asking for. Then
Well, I haven't read the statute. If you did have your thing, I could read it, maybe, the statute. Then
I just read it to you.
inform a decision on it.
The court can read it to you verbatim, word for word, if you'd like.
Sure.
I imagine he has it too.
Actually, you know what? I'm going to pull it up and print it out for you. That way you can look right at it. That way you can look
We're
right at
talking
it.
about inability to pay. There's a whole different issue. No one has jailed you for inability to pay yet. So
No, I'm just saying,
there's a hearing
just
process.
making the kind of statement now, in case somebody can give him a chance.
And I, as your co-counsel, are trying to kind of keep you on the rails for what you legally would be the right way to make that argument. An inability to pay hearing is different than saying you can't give me fines. The whole debtor's prison, what you're talking about, you're kind of on the right track, but you're not arguing correctly, if that makes sense. Okay.
I was not correct on this, but Constitution says.
What I'm trying to tell you is it's legal to impose fines. Your argument about whether you can pay them or not would be a different argument.
Well,
So these are the applicable subsections 3, 4. And Your Honor, we're still waiting for real guidance from the Court of Appeals on what some of those factors that are in that rebuttable presumption. I've appealed, I don't know, half a dozen.
I think the whole statute personally is unconstitutional because it usurps power from the judiciary as the ability to. There's a statute that the legislature can pass. They can put the fines and costs. They can put what the parameters of punishment are. 93 days, 90 days, 100 days to 5 years, put whatever you want on it. And then it becomes my job to decide what it should be. I still think it's unconstitutional.
And I feel like the only reason it facially even passed was that that subparagraph bounces it back to you guys without any real guidance.
It does.
As to what that exactly would
Again,
be,
I'm not even sure that they should give guidance in that, because that's still the prerogative of things, so.
It feels, I guess, best like a poor attempt at mimicking the sentencing guidelines, maybe. I don't know where they're going with it. But I know that in district court, we've been getting a lot of appeals out of this exact statute. So you and I don't stand alone in our feelings about
I
it.
am going to call people of the city of Taylor versus Aaron Drake while you're reading that.
Thank you, Your Honor.
So there is no real money in circulation anyways, as said by the U.S. Supreme Court, so I couldn't really pay it anyways. Like that. So it should be discharged, again, I repeat myself on this one, but be discharged under House Joint Resolution -192, any so-called debts. And 12 U.S.C. Section 411, it should be discharged. That's all I have to say on that matter.
All right. Counsel, was there anything you wanted to add?
Just very briefly, Your Honor, I'd like to point out that this is a non-violent offense, that this individual has availed himself to the court, albeit a little bit late. He made the effort to get on the bike and get up here. Those are the positive factors I'd like to point out to the court before sentencing.
All right, so having taken everything into consideration, here is my sentence. I am going to sentence you to 12 days in jail. And here's why. First off, I'm going to waive the fines and costs. I'm not even going to bother with the fines and costs. You're unemployed right now. You're looking for employment, so I'm not going to put an extra burden on you when you're already trying to feed yourself and whatnot. So I could, but I don't think it's necessary.